Hi everyone, thank you for joining us this morning. My name is Alex Hahn, and I'm one of the vice presidents of Evans.
And I'm Ashley Johnson. I'm the other vice president of Evans, and we want to welcome all of you to the final round of the 2022 Evans A. Evans Constitutional Law Moot Court Competition. So congratulations to our two final teams. But before we begin the final round, we would first like to introduce our esteemed panel of justices. So first, we're happy to welcome Justice Rives Kistler. Justice Kistler graduated from Georgetown University Law Center, after which he clerked for Chief Judge Charles Clark on the Fifth Circuit and for Justice Lewis Powell Jr. on the U.S. Supreme Court. Afterwards, he worked at a civil litigation firm in the Appellate Division of the Oregon Department of Justice. He was appointed as a judge on the Oregon Court of Appeals in 1999 and as a justice on the Oregon Supreme Court in 2003, where he served until 2019. Since that time, he has served as a senior judge on the Oregon Appellate Courts.
Next, we have Justice Louis Butler. Justice Butler served as an appellate and trial attorney at the Public Defender's Office and was Wisconsin's first public defender to argue before the U.S. Supreme Court. He was then a Milwaukee municipal judge for 10 years and was elected to the Circuit Court in Milwaukee County. He was appointed to the Wisconsin Supreme Court in 2004. He also taught at the UW Law School before going into private practice. He is a distinguished faculty member at the National Judicial College in Reno, Nevada, where he has taught for more than 23 years.
Next up, we have Judge Nancy Joseph. She graduated with her Bachelor of Arts from Howard University, got her JD from Rutgers University School of Law, and her LLM degree from Duke University School of Law. Judge Joseph was appointed as U.S. Magistrate Judge in the U.S. District Court for the Eastern District of Wisconsin in 2010. She also previously worked as a trial and appellate attorney with the Federal Defender Services of Wisconsin, and she has served on multiple committees, including the U.S. Court's Magistrate Judge Advisory Committee. She's also very active in civics education and programs for youth and has been recognized numerous times for her outreach to youth.
Next up is Justice Rebecca Frank Dallet. Justice Dallet received her BA from Ohio State University and her JD from Case Western Reserve University School of Law. Immediately after, she clerked for Magistrate Judge Aaron Goodstein of the U.S. District Court for the Eastern District of Wisconsin. She then served as the first female presiding court commissioner for Milwaukee County and as a Milwaukee County Assistant District Attorney and a Special Assistant U.S. Attorney for the Eastern District of Wisconsin. After that, she served as a judge of the Milwaukee County Circuit Court, elected in 2008 and re-elected in 2014. Most recently, Justice Dallet was elected to the Wisconsin Supreme Court in 2018.
And lastly, we're happy to welcome Judge Ronald Lee Gilman. Judge Gilman earned his Bachelor of Science from Massachusetts Institute of Technology and his JD from Harvard Law. After that, he joined a Memphis law firm where he practiced for 30 years. Judge Gilman held many leadership roles with the Memphis and Tennessee Bar Associations, was an adjunct professor at the University of Memphis Law School, and wrote a book and 13 articles on various legal topics. In 1997, President Bill Clinton appointed him to the U.S. Court of Appeals for the Sixth Circuit. After 13 years of full-time service as a federal judge, he took senior status and now sits as a visiting judge with other circuits throughout the country. As of 2021, he has written over 1,200 judicial opinions.
We are happy to welcome this panel of esteemed justices, and we want to thank all of them for joining us today. Now that we have welcomed our justices, we will turn it over to Bailiff Castaneda. He will cover a few matters with our competitors. Best of luck, everyone.
All right. Hi, everyone. Welcome to the final round. Before we get started with housekeeping, I would just like to take a picture of everybody, if that's okay with everybody. Is that okay with everybody? All right, ready? In 3, 2, 1. All right, thank you. Okay, great. As mentioned, I am Bailiff Castaneda, and we will begin with some housekeeping. So I will keep time and I will flash cards. They will look like this. I will give you a warning at 10, 5, 3, 1, and stop. All right, so let's get the rebuttal out of the way. So petitioners, if you guys could please let me know if you do, or how much time you guys are reserving for rebuttal.
Yes, we're hoping to reserve 2 minutes for rebuttal.
Okay. 2 minutes. And then, so can we go in the order? So petitioner A, who will be the first person?
I'll be arguing issue A, and my co-counsel, Ms. Granucci, will be arguing issue B.
Okay. And I just want to make sure I'm pronouncing your name correctly. Zarone, or is it Zarone?
Zarone.
Zarone. So you will be arguing, you are petitioner A. Justices, I hope you make note of this. And then petitioner Guy, you will be arguing the second issue, right?
No, that would be Ms. Granucci.
Oh, I'm sorry. In my screen. Okay, thank you so much. And then how much time who's rebuttal time coming out of, or how's that working?
We intend to take 2 minutes of Ms. Granucci's time for rebuttal out of
Okay.
issue 2.
So then you will be arguing for 15 and she'll be arguing for 13?
Yes.
Okay, 13 minutes. Thank you. And then respondent, can you guys please tell me who respondent A is and respondent B will be?
Hi, this is Amira Guy. I'm respondent A, and Paul Piazza would be respondent B.
And you guys will be arguing 15 minutes each. Justice, are you guys okay with the order and the names and the team numbers?
We are
Okay.
okay with all of that. Thank you.
Awesome. All right, so I'll just reminder petitioners, please remember to ask to reserve time in your argument when we get started. So things will be a little bit different in this round. We mentioned this at the beginning, well, earlier before we started, that the justices will, when it's over, they will provide feedback to everybody rather than breaking off scoring. So they will begin with feedback. And once feedback is over, the competitors are free to go, that this webinar actually will be over, and the justices, you will receive, if you haven't already, a link to join a deliberating meeting link. And you guys will hop onto that link and deliberate with each other. And then our vice presidents will then join about 10 minutes in to make sure everything is going okay. And then we will announce at the award ceremony who have won the competition, which begins at 12 p.m. Central Time. So that is the housekeeping. Is everybody okay?
Mr. Bailiff, this
Yes.
is Justice Butler, and I have a question.
Yes.
When we've done these competitions in the past, after the parties generally argue, in the past, what we've done is the justices have gone back and deliberated for a few minutes before coming out, giving feedback and announcing our decision. It sounds like you're trying to do it differently this time, or is that fine?
No, yes, you're correct. We are doing it differently. So you guys will begin with feedback first, and then you'll be deliberating.
Feedback, then deliberating. Okay.
Yes, I'll be sure to remind everyone once we have finished. So, all right. So okay, so do we have any more questions? All right, awesome. So we will begin if everybody is ready. Okay. The Supreme Court of the United States is now in session. The court will hear the matter of Robin Blake versus Nadia Delgado and City of Washburn. You may begin.
Good morning, Your Honors. Madam Chief Justice, may it please the court. My name is Jake Zarone, and I, alongside my co-counsel, Ms. Isabella Granucci, represent the petitioner, Officer Blake. Today, I'll be addressing the first issue. This is whether Representative Delgado violated petitioner's First Amendment rights by blocking her on social media. My co-counsel will address the second issue of how the Washburn Police Department violated petitioner's First Amendment rights by firing her for engaging in protected speech. At this time, I would like to reserve 2 minutes of my co-counsel's time for rebuttal. Thank you.
That will be granted.
Thank you. Your Honors, if the First Amendment means anything, it has to protect a citizen's right to voice their opinion on their government. And public officials should not be granted free rein to silence the voices of the people. Thus, this court should reverse the ruling of the 14th Circuit for the following two reasons. First, under the nexus test, the trappings of the @Nadia Delgado account weigh in favor of designating the account as that of a state actor. And second, the @Nadia Delgado account evolved from a personal account to a state account because it was used as a tool of governance.
So with respect to the first point, Mr. Zarone, are you saying that anytime anyone is campaigning and talking about policy issues, that would transform a personal account into a government one? And if not, when would that line be reached?
Your Honor, we are asking this court to consider the amount of commingling that has occurred on this account. So it is not merely just that Ms. Delgado is campaigning here. What we are asking the court to look at is how is respondent presenting herself to the public. In addition to that, what is the content of the tweets that she's been posting? And with these two factors combined, does that give the impression, under a totality of the circumstances analysis, does that give the impression that this is the account of a state actor?
So temporally, how should we view her account? Do we look at it from the beginning or a point in time forward?
Your Honor, we'd ask that the court look at the count in this circumstances from when she was elected and how she's used it since she was elected. Now, Your Honor, to quickly orient the court, page 10 of the record indicates that Officer Blake, as a community member, tried to direct her concerns towards Ms. Delgado via Twitter in hopes that Delgado would help restore the local conditions in District 16. After several posts about public safety issues, Officer Blake commented on Delgado's Twitter post to quote, "Please help," unquote. Now, per page 10 of the record, rather than responding to Officer Blake's pleas, Delgado blocked her from the @Nadia Delgado account. Now, it's very important to note that on page 12 of the record, it's been conceded by both parties that the interactive space from which petitioner was blocked is a designated public forum. And it is also—
Mr. Zarone, may I interrupt you, please? Although Blake was blocked from the account in question, Delgado had another account, the state rep account, which was set up by the government. So how are we to look at, to weigh this? In fact, that Blake still had access to voice her concerns as a citizen on the state rep account.
Well, Your Honor, this other avenues of communication is something that could be considered or should be considered if we were to find this as a reasonable time, place, manner restriction. However, here that is not the case. As indicated on page 12 of the record, it has further been conceded that the basis for the blocking was the content of the post. That is to say, petitioner was blocked because of her viewpoint. And no matter what the type of forum, whether it be public or a designated forum, viewpoint discrimination is prohibited. And even if there are other avenues, that should not be relevant to the fact that someone was blocked because of what they were saying.
Mr. Zarone, before we get to the actual blockage, I'm still having trouble with the fact, and to follow up just Joseph's question, there are two accounts here. One is the legislative account, the other is a personal account that had been used for personal reasons and campaign reasons. Can you tell me where in the record there's some indication that the Ms. Delgado was actually doing legislation or her state representative duties on the personal or campaign account?
Yes, Your Honor. Per page 7 and 8 of the record, it has been conceded by a respondent that this is the account she uses most. And to give you specific—
But uses for what purpose?
Well, uses for purposes of announcing policy. So to give you specific examples, there are 15 tweets in the record on page 7 and 8. 9 of these tweets relate to her actions taken in her official capacity. Specifically, as noted on page 8 of the record, she's posted tweets announcing that she's co-sponsoring bills, and another is a picture of her speaking on the House floor about a bill that she was supporting. These are 2 examples of her carrying out her official duties as a legislator And
But
her-
just to follow up my question, you're talking about her talking to her constituents about what she's doing as a legislator. That's different than talking to the other legislators about the business of legislating. And so what I'm looking at is where in the record there's any indication that she was actually using that personal / campaign account to communicate with her other legislators in terms of creating legislation.
Well, Your Honor, while she may not have been directly communicating with other legislators, or the record may not demonstrate such, it should be noted that she is still using this account as a tool of governance. So while she may not be voting on the account, she is still using it to reach out to her constituencies, which is something we expect of all legislators. That is the core role of a representative. They are representing the people, and therefore they are beholden to the people, and they need to inform the people of what's going on in their government and what they're doing. And that's exactly what Respondent is using this account to do.
So,
Now, let me ask
Mr.
you-
Zarone, you should go, Judge Gilman.
Let me just ask, the Eighth Circuit case of that Campbell v. Rice is directly contrary to your position. How do you distinguish that case?
Yes, Your Honor. Campbell versus Rice does have some similarities. However, there is one key distinction that should be noted. In Campbell versus Rice, the account was created. The account in question there was created for the explicit purpose of campaigning, explicitly designated as a campaign account. Here, that is not the case. Page 5 of the record indicates that Respondent created the account as an activist and then decided to run for office. So the account then evolved to that of a campaigning account, and it has once again evolved to that of the account of a state representative. And this is very analogous to Knight versus Trump, where we saw the former president's personal account evolve from one that was personal to one that became official, although he had a second official account, which was the @POTUS account. So this is all to say, sorry, Your Honor.
Mr. Let me interrupt you for a second. The 9 instances you mentioned, some of those are ambiguous, potentially. Some appear to be counting candidate statements that have policy implications, and some appear to be counting appearances with Girl Scouts, sort of public outreach kind of things. How should we factor in what arguably are ambiguous tweets, which could be counted as candidacy or perhaps even personal statements? And it's the second piece, I apologize for the follow-up. What percentage, in your view, of policy statements are necessary to convert a candidacy or private account into a policy account?
Well, Your Honor, I can answer both those questions in turn. Overall, there is no exact number we're proposing to the court, but we are asking the court review in the totality of the circumstances to see, is the majority of the count presenting itself as that of a public official? So while there is some ambiguity into the specific tweets themselves, the clarity comes in when we look to see how is the account being presented to the public. That is to say, is the account swathed in the trappings of the official's office? This was articulated in Davison versus Randall, where the Second Circuit reviewed an official's Facebook page and found that there were certain factors on the page that indicated it was that of a public official. That is to say, the title of the official, there were contact information for the office. There were links posted.
But I take it Davidson, that was predominantly used for policy statements. Whereas here, there's arguably a greater mix of personal candidacy and policy stuff. And you've got her sort of little head picture where it's her with her dog, and then you've got the background picture of her at the candidate podium. What do we do with that mixed message?
Your Honor, that mixed message certainly creates confusion. It creates confusion for constituents who are going to this page and seeking information. And at the end of the day, what it comes to show is that people are finding this to be that of a public official. And so we assume that there should be, or propose there should be some sort of rebuttable presumption here, that if you are commingling your page to this extent, if you are showing that, these many aspects of your life in office, then it is safe to say you are a state actor. for these purposes. And so when someone comes to your page and comments on a post with a critical view, in your opinion, you should not be able to exclude them for simply sharing a critical point of view. That is where the line gets crossed because how the page is presented and because there are policy statements. There are 60% of the page consists of things related to respondents' work in office. And that moves the needle from private action to state action.
Mr. Zarone, you've touched in different responses to some of the factors you would like for us to incorporate into a test, if you will. But if you would just take a second and articulate, what is the rule that you want us to put together here so that we could instruct the lower courts when this issue come up? So I'm asking for your elevator concise rule that you would like us to articulate to the lower courts.
Your Honor, we are asking that courts review facts like this under a totality of the circumstances analysis, and then apply a rebuttable presumption if the majority of the page presents itself as that of a public official.
And under the totality, what are some of the factors that we should instruct the courts to look at?
Courts should look to see how is the account presented. That is, what are the trappings on the account? How are people receiving this account? So if one goes to the page, are they seeing an official phone number, as is the case here? Factors like that. So how is it presented? And also, what is being said on the account? Are they referring to policy consistently throughout their time in office? And that is the case here as well. And so under these two prongs, this presentation and this content prong, it becomes evident that this is the account of a state actor.
Mr. Zarone, I'm sorry, Justice Kistler, go ahead.
Now, if we bought your model, how would you rebut a preponderance of evidence in your view? In other words, once it's 51% leaning towards policy, what would the congressperson show or the state representative show to rebut it?
Well, Your Honor,
because you said the presumption was rebuttable.
absolutely. If one was to attempt to, rebut such presumption, they could possibly claim that it was campaign activity. However, that would be a very slippery slope, as is the case here, where we could walk into an area that allows a public official to claim that anything they put on their page is campaign activity, and therefore they're not accountable to their constituency. So all this is to say is it becomes very difficult to rebut such presumption when it rises to the level that it has here.
Mr. Zarone, I'm about to ask you what may be considered an unfair question, although it's a follow-up to questions by Justice Kistler, Justice Gilman, and Justice Dallet, Chief Justice. But I believe it was Campbell versus Rives. The court makes passing reference to the First Amendment rights of a candidate to campaign. I didn't spend a lot of time talking about it, but I think back in terms of our precedent in Caperton versus Massey, Citizens United, and the rights of candidates to campaign actively and pretty much say almost anything during a political campaign versus what the situation was in I believe it was Campbell, where they designated this is a chairman's page. So it separated it out. It wasn't just for campaigning, it was for other purposes, or for purposes of actually doing legislation. So when I think about that First Amendment right of the candidates, if we rule in your favor, aren't we taking away from the rights of the candidate to campaign? I see your stoplight is on. Please answer my question if the chief will allow it.
Yes, please answer the question.
Thank you. Your Honor, this would not be chilling any First Amendment rights of a candidate. By putting this policy in place, or by ruling in this direction, it would simply send a message that, yes, if you are campaigning, you can do so. As an incumbent, you are still likely to win regardless. You have that advantage. But one must be very cognizant and careful with what they are posting on that account. With all this power, Your Honor, that we give our Congress people and our representatives, There is an expectation they demonstrate it and exercise it with some degree of responsibility. And so all we are asking is this court announce that and make that very clear to representatives that they cannot exclude people and then hide behind the claim that it's campaign speech. Thank you.
Thank you. All right, Ms. Granucci.
Good morning, Your Honors. Madam Chief Justice, may it please the court. My name is Isabella Granucci, and I represent Petitioner, Officer Blake. Today, I will address the second issue, how the Washburn Police Department violated Officer Blake's First Amendment rights when they fired her for engaging in protected speech. Citizens do not abandon their free speech rights when they become government employees. The First Amendment protects a government employee's right to raise issues of discrimination on the police force. Accordingly, this court should reverse the decision of the 14th Circuit Court of Appeals for two reasons. First, Officer Blake spoke as a private citizen on a matter of public concern, the lack of diversity at the Washburn Police Department. Second, applying the Pickering balancing test in this case, the interests of Officer Blake outweigh the government's interest. To directly answer the question on cert, the First Amendment protects a government employee's speech when the employee speaks as a private citizen on a matter of public concern. To protect this fundamental right, this court created the Pickering balancing test, which requires the government to show that its interest as an employer outweighs the employee's free speech interest.
Ms. Granucci, I'm curious, she made the statement, your client made the statement with regard to she made it to three officers, two of whom were just peers. What is the significance of the fact that Officer Sampson was one of the people she made the statement to? And what if Officer Sampson had not been there and she was merely making the statement to her two peers?
Your Honor, as this court held in Connick versus Myers, it's important to look at the content, form, and context of the speech to determine if it addresses a matter of public concern. So here, she made it in front of two other committee members and her direct supervisor while gender discrimination was actually taking place at this meeting. So had her supervisor not been there, the fact still remains that she was addressing a matter of public concern, as the content is the weighing the heaviest in this situation, that she was trying to bring to light a serious issue of gender discrimination within the police department.
Ms. Granucci, where do we draw the line between a personal concern and a public concern in the context of what happened here?
Your Honor, it's important to look at the statement in the totality. So looking at the content, form, and context of the speech. And this court showed in Connick that it is a very low threshold for speech to be considered on a matter of public concern. So when the content weighs heavily in favor of it being a matter of public concern, then the context and form must weigh heavily in the other situation. So even though here, Officer Blake did touch on her own personal issues with gender discrimination, it doesn't overshadow her motive to bring to light serious issues within the Washburn Police Department.
So, counsel, my memory of Connick is that the court sought to balance both public, if it's a matter of public concern, and also the employer's interest in sort of running an efficient workplace, not so much whether there are other reasons for firing this employee. If you're right, what's left of that other piece of Connick and Pickering? Because it seems to me there was at least proven disruption within the office. So do those just drop out?
No, Your Honor. So once this court determines that the speech is on a matter of public concern, as it was here, then the burden turns to the government to show that its interests in operating efficiently outweigh the employee's free speech interest. So this brings me to my second point. Officer Blake's interests in this case and bringing to light a lack of gender diversity in the Washburn Police Department outweighs the employee's interest in operating efficiently.
And why is that?
Because, Your Honor, the burden turns to the government to show that the employee's speech has actually affected the efficiency of the workplace, which here, as seen on pages 9 and 10 of the record, Officer Blake's speech did not affect the efficiency of the Washburn Police Department. Specifically, as seen on page 9 of the record, after her speech was made, and even though she sensed hostility and unfriendliness from the other officers, she was still able to work with them to safely and successfully de-escalate a very dangerous situation. So,
but in the context, and I realize it may change in the context of sex and race discrimination claims, but what do you do with the fact that 2 of the officers didn't want to work with her and wanted to be as far away from her as they could be?
Your Honor, that just goes to show.
In the meeting.
Yes, Your Honor. And while we do recognize that perhaps this was not the best situation for Officer Blake to stand up and speak on a matter of gender discrimination, because in an ideal world, she would have given this speech at a police department town hall meeting where the public was present and where she didn't address anything personal or pertaining to anyone else. However,
and just let me stop you for a second. When Justice White referred in the footnote to context, form, and whatever, that was what he was talking about, wasn't he? Because it wasn't only content, it was the manner in which you presented the grievance. And did that affect the internal workings of the office? And so that's, again, I'm not saying that you aren't right, but it just seems to me that that's a piece of it.
yes, Your Honor. And while it is a piece of this balancing factors, and while it is to be taken into consideration, the First Amendment doesn't require a perfect situation for an employee's speech to be protected under the First Amendment. All it requires is that employee speak as a private citizen on a matter of public concern, and that those interests outweigh the government's interest. And here, although the 2 other officers said that they felt uncomfortable around her, that was only 2 officers within the entire police department, and she was still able to work with them. And it doesn't indicate that the public was privy to this conversation, so it didn't affect the Washburn's Police Department's relationships with the people that it served, or truly disrupt any of the inner workings of the Washburn Police Department.
You know, it sounds to me like that she's fussing at what Wilder and Buchanan because they were interested more in sports and beer, right? That was her beef. And that sounds just really just a personal problem. And you say she didn't voice it at a public meeting or anything and just walked out, stormed out of, I guess, that little committee meeting. So what makes this a matter of public concern?
Your Honor, when viewed in the totality of the circumstances, it shows that Officer Blake's speech was a buildup. First, as seen on page 9 of the record, she recognized that there was a problem with the lack of gender diversity within the Washburn Police Department. And second, then she actively tried to change the status quo, as seen on page 9 of the record, by referring qualified women to apply to work there, none of whom were hired. And then finally, in the moment that gender discrimination was actually taking place, when the other officers ended the meeting early, cut out her presentation so that they could go to a bar and drink beer and watch sports, she spoke up about it. So it was in a real life example of when such discrimination that she was talking about was actually taking place. So it doesn't necessarily discount her true motive here to bring to light serious issues.
Ms. Granucci, there's one thing in the record, and I forget where I saw it in the record, so I apologize for that. But there's one thing in the record that concerns me about your client's position. And that's the fact that apparently she neglected some of her committee duties and committee responsibilities. Now, if she's neglecting her responsibilities, wouldn't Washburn have the right to actually fire her for not performing the duties that she was hired to do?
Yes, Your Honor. Well, that concern is very legitimate. The record indicates that she prioritized her work with other departments in the police department. So it wasn't necessarily an abandonment of her police duties. It was a reprioritization. And here, after the other members of the committee made it apparent that they didn't value her opinion or her work, it may have been rightfully so that she prioritized other work, perhaps where her opinion and where her work was more valued and more necessary. And it's also important to remember here, Your Honors, that when Officer Blake spoke, she was also an employee of the police department. So she was bringing to light these issues to help promote the efficiency of the police department so that they could fix these issues of gender discrimination and operate at their highest efficiency. And in turn, she was silenced and fired for bringing to light issues that she was trying to fix. In Connick, this court recognized—
That was true. Wasn't that true in Connick also? The employee was trying to bring to light the inefficiency in her view of reassigning people. And the court said, nah, not good enough.
Yes, Your Honor, in Connick, that is true. However, in Connick, the reasoning was that they saw her speech as being a threat to the supervision and to the higher ups within the department that the plaintiff there gave her speech. However, here that's not the case because Officer Blake's speech was made to only 3 other people and no one else was even made aware of this speech. So it didn't threaten such employee workplace or threaten the supervision of anyone within the police department because no one was really made aware of it.
So does the claim of sex discrimination set this apart from Connick in a way that is difficult to compare the two cases?
Your Honor, because it is sex discrimination, and this court has held that that is a heightened issue of public concern, it does just strengthen Officer Blake's interest in speaking on it. And Officer Blake had worked at the police department for 5 years, so she had an informed opinion on the inner workings of the police department. And in Garcetti versus Caballos, this court held that that is exactly the informed opinions that the First Amendment is trying to protect. We want to protect the informed opinions of employees who can speak out and raise awareness about issues of public concern within their workplace.
Ms. Granucci, you now have 1 minute left, so I think you wanted to reserve 2 for rebuttal, so we should stop at this point.
Yes, Your Honor, thank you.
All right, is it Ms. Guy that is next?
Yes.
Okay, you may begin.
Good morning.
I'm sorry, I want to interrupt. Petitioner B, yes, she had 1 minute left, but she had reserved 2 minutes before. So she should finish her minute. I'm sorry.
Oh, I'm sorry. So it was 1 minute and the 2 was already reserved.
Yes, I'm
All right,
sorry.
I lost track of that. That's on me, Ms. Granucci. If you have 1 minute left, would you like to why don't you give us your best argument in your last minute?
Great. I would just like to use this last minute to conclude. Thank you, Chief Justice. Your Honors, we recognize that law enforcement organizations do have a strong interest in preventing disruption and fostering trust and collaboration among employees. However, this interest is not absolute. Respondent has not demonstrated that this interest was substantially jeopardized by Officer Blake's speech. Therefore, her speech should be protected under the First Amendment. For those reasons, we respectfully request that this court reverse the decision of the 14th Circuit Court of Appeals. Thank you.
All right, thank you. Okay, I think now we're ready for you, Ms. Guy.
Good morning, Your Honors, Madam Chief Justice, and may it please the court. My name is Amira Guy, and I, along with my co-counsel, Paul Piazza, represent defendant respondents, Representative Nadia Delgado, and the City of Washburn Metropolitan Police Department. This court should affirm both rulings of the 14th Circuit Court of Appeals. I will address the first issue, the constitutional right of Representative Delgado to block Ms. Blake from her personal @Nadio Delgado Twitter account. My co-counsel will address the second issue, Ms. Blake's justifiable termination by the Washburn Police Department. To our first argument, the First Amendment states, Congress shall make no law abridging the freedom of speech. However, the Supreme Court in Manhattan Community Access Corporation versus Halleck held that the First Amendment prohibits only governmental abridgment of speech and does not prohibit private abridgment of speech. A public employee acts under the color of state law while acting in his official capacity. Nevertheless, private actions can only be fairly treated as being under the color of state law when the private actions bear a sufficiently close nexus to the state. When looking at the totality of circumstances surrounding Representative Delgado's use of her @Nadio Delgado Twitter account, this court should find that there is no sufficiently close nexus between actions and the state to justify considering her actions as being done under the color of state law for the following three reasons. First, Respondent Delgado was not acting under the color of state law when using her Twitter account, as this account cannot be deemed as a tool of governance. Second, looking at the totality of the circumstances as required by Skinner versus Railway Labor Executives Association, the @Nadio Delgado Twitter account must be considered akin to that of a campaign newsletter. Third, Representative Delgado's own First Amendment right to maintain control of her campaign messaging is under attack, and the court should protect the ability of elected officials to use social media as a campaign tool.
With respect to your first point, Ms. Guy, are you asking us to conclude that Twitter can never be a tool of governance?
No, Your Honor. In this case, I'm asking the court to find that with Representative Delgado's Twitter account, that she did not use this account as a tool of governance. And as seen in Knight, First Amendment, and also in Davison versus Randall, we're able to see that these accounts were used as a tool of governance in the sense that specifically with former President Trump, he used his account as a means of engaging with foreign political leaders, hiring and terminating political officials. We're seeing him use his executive official power through this Twitter account. However, in this case, with Representative Delgado, she is a legislator. So when she is operating through her Twitter account, you should be able to see her exercise her official duties. And as a legislator, she is focusing on bills and voting. And this differs from how the individuals in Davison v. Randall and in the Trump case acted. And in this, we established this difference as there was not a tool of governance seen here with this @Nadio Delgado Twitter account.
Ms. Guy, didn't Representative Delgado, she posted, I believe, picture of her and the governor. She made posting in reference to bills. So aren't those using that specific account related to her business as a legislator?
As my friends on the other side stated, that these are trappings of an official office, Your Honor. When you're looking at the state seal, when you're seeing these official capacity, seeing this Representative Delgado take part in these official duties. However, when we're looking at this Twitter account, we have seen in other cases that trappings alone are not enough to be a signal of a tool of governance.
So let me interrupt you for a second if I can. Do you agree with the other side that we should look at the totality of circumstances from the point in time when she became an elected official? That
No,
is, everything after that, if we start looking at her use of the Twitter account, or do you think we should look at it before then?
No, Your Honor. When you're looking at totality of circumstances, you're looking at the Twitter account as a whole. And to start when the Twitter account, when she became elected, is not looking at the totality of the account. And since the account was created in 2015.
So let me stop you on that and push back just a second. Why is that? Can't the use of an account change over time? That what became as a personal account become solely a policy forum so that she could, in other words, once she became elected, if she put everything on the account having to do with policy, would you still say we would try to look at the thing over time? That's my sort of difficulty with your position.
Yes, Your Honor. When you're looking at the totality of circumstances, you're looking at the account as a whole. So when we're looking at this account, and even as seen in Campbell versus Rice, the account can morph, it can change, it can evolve. And that's the beautiful part about social media. It is a modern public square. It is a new era for the courts. It's a new era for society. So when the court is looking at this, you're setting a precedent, a case of first impression.
Well,
so we want to make sure when we're looking.
Ms. Guy, so being this this social media being so new, and let me just tell you here, I'm old school. I don't tweet, I don't Facebook, I don't social media. I don't understand any of that stuff. So I'm going to need some help here. But when I look at how social media is being used by some, it is clear that, and I think the Trump case is an example, it's clear that some people use this for purposes of legislating, for purposes of campaigning. They kind of blend the lines, they merge them in such a way so that it's hard to tell where one ends and one begins. How are we, if we're going to come up with a decision that governs going forward, where do we draw the lines? How do we determine when it's campaign or when or is it always going to be, now that we have this new forum, that, okay, it's now, if you're talking here, you're legislating here? Where do we draw the line?
Your Honor, there is no bright line rule. When, as you state, with this new era of social media, things can easily be intermingled and intertwined, as campaigning is essential to how our elected officials run their offices, how they go about their daily lives. Some would say everything they do is about being reelected. So when you're looking at their accounts, we have a responsibility to look at the account as a whole. What is the message that the account is sending? How would people look at this account? And when we look at the lower courts, they have established a state action test that focuses on two main points. Was it a tool of governance? And then also, was it in private interest of that individual? And as stated earlier to that first point, it was not a tool of governance. We're not able to see Representative Delgado who would use this as an official duty for her of voting on legislation, and voting on bills. What we see her doing is merely updating her constituents on that she is fulfilling their promises as an incumbent, as an elected official.
Ms. Guy, if I may jump in here on the issue of tool of governance, what would that look like? Would she put a live feed of her voting on specific bills? What does that look like for Ms. Blake?
Your Honor, for Representative Delgado, we would see a tool of governance if she was actively engaging with other legislators. If she was talking about bills, talking about the individual sections or debating. If she was also going through her voting, as you say, a live feed, that is an official capacity to be able to look inside a state office and being able to see legislator votes, hearing her give these speeches that are very official capacity and calling, as we see with former President Trump, calling on other foreign political leaders to engage. There is no solicitation seen on Representative Delgado's account for this type of business to occur. And this brings me to my second point.
So I just want to understand this, Ms. Guy. It seems that you are restricting for a tool of governance. It should only be communication with other legislators. So if she's communicating with the public, then you drawing a line. When is governance and when it's talking to the public constituents.
Oh, let me clarify, Your Honor. I also want to not just focus on communication as well. I think, especially with her position as a legislator, she is restricted in her position on what her official business is and how that can be enacted on social media. We're seeing with executive officials, they have more ability to use social media as more of an official place for their governance. as seen in Davison and Knight. So Representative Delgado is already restricted. She already cannot do a lot of governance on the social media page, which furthers my point that it cannot be seen as a page of governance as she is so restricted. Which brings me to my second point here, which focuses on that when you're looking at the totality of circumstances, you want to look at the Twitter account as a whole. This Twitter account began in 2015, and we're able to see that it was created 3 years before her candidacy and 4 years before she was sworn into office. And on page 5 of the record, I direct your attention. The display name has remained at Nadio Delgado. On page 6 of the record, Delgado's profile picture is a photo of her and her dog at Lathrop Park. And especially too with social media, the profile picture is your representation, an avatar to the public. From a general understanding, many people go to far extent to choose the right profile picture on how they will present themselves. And we see this right on the front that Representative Delgado is presenting herself in a personal nature and a campaign.
But let me stop you for a second. Isn't the profile picture that little oval, which is smaller in relation to the banner of her standing behind the podium for the state representative? So if you sort of look at representative size, the state representative seems to be the larger message.
And can you also, will you address Justice Kistler's question? And also it's a similar question. What about the fact that the phone number is the government phone number?
Your Honor, these are trappings of an official duty. However, as seen with trappings, they are not a sole factor that can determine whether it is of a government nature. So when we're looking at the totality of the circumstances, yes, these are factors. However, looking at the record, we're able to see 12 tweets in the record that are solely campaign purposes. And also too, on the record as well, we were able to see in that bio, on page 5 of the record, she has a hyperlink directly to her fundraising platform. Furthermore, she uses the page as a campaign newsletter where she's able to, on page 8, directly go against her opponent, Clay Pierce. On page 6 of the record, we're able to see that she routinely tweeted about central tenets of her campaign platform: police reform, affordable housing, and anti-hunger initiatives. As this account—
Ms. Guy, you don't have a lot of time left, and we really don't want you to leave without giving us the succinct rule that you want us to apply to instruct the lower courts. As you mentioned, this is an issue of first impression. So as we had asked Mr. Zarone, what's the succinct rule, as best as you can articulate it, your elevator pitch of the rule that we should adopt to guide the lower courts?
Your Honor, the rule that this court should adopt is the state action test, where it relies on the court's good judgment to determine whether a public official wielded powers that could only be fairly attributed to the state authority through this account. And as using Skinner and focusing on the totality of this account, this rule will allow the court to look at these cases on a case-by-case basis and making sure that we are not only holding public officials accountable for making sure that their private accounts are private, but we're also, to Your Honor, with this rule going to be able to make sure that we are protecting the rights of elected officials as well. And as I briefly stated before, an elected official can't just sell a dream. They also have to show that they are keeping their promises. And social media, it allows for a platform that elected officials are able to do this. This court noted that the forces and directions of the internet are so new, so far reaching. And as such, in Section 1983, we want to make sure that we are protecting the rights of representatives as well, as a citizen who works for the government is nonetheless still a citizen. And Representative Delgado will be at a disadvantage to her opponents if she is not able to curate her campaign message as she sees fit, including censoring at people at odds with her message. And while Ms. Blake has various means of getting in contact with her representative, via phone, email, in person, or through the government official account created for Representative Delgado when she took office. Your Honors, I see my time is up. May I please briefly conclude?
I'll give you one short sentence since we went a little bit longer on the last question for Mr. Zarone. Go ahead.
Yes. For the foregoing reasons, we respectfully request that the court affirm the 14th Circuit Court of Appeals decision and find that Representative Delgado did not act under the color of state law when blocking Ms. Blake from accessing her @Nato Delgado Twitter account. Thank you.
All right, thank you. Mr. Piazza.
Good morning, Madam Chief Justice, and may it please the court. My name is Paul Piazza, and I represent the defendant respondent, City of Washburn, against Petitioner Blake's termination claim. Ms. Blake's First Amendment rights were not violated when she was terminated for disrupting the efficiency and cohesion of the Washburn Police Department. Under the tests laid out by this court in Garcetti versus Sabalos and Pickering versus Board of Education, as refined by Connick versus Myers, the City of Washburn properly terminated Ms. Blake from the Washburn Police Department for 3 reasons. First, the form, context, and substance of the speech at issue was primarily of a personal grievance rather than on a matter of public concern. Second, the City of Washburn had a justifiable expectation of significant disruption to the workings of the police department at the time of her firing. Third, the specific nature of Ms. Blake's speech was not sufficiently important to outweigh the expected disruption to the department. I will take each argument in turn. First, under Garcetti versus Sabalos, a public employee speech must be examined for whether it regarded a matter of public concern first, before courts can even consider whether it deserved First Amendment protections. Courts examine the speech itself as a matter of law, and courts have held that speech regarding a private grievance does not garner First Amendment protections, and that just because an issue of social importance is included in an expression of a personal grievance, such speech does not automatically become of public concern. Here, the form and context of Ms. Blake's speech especially shows it was expressing a private grievance rather than a matter of public concern. As to the context of her speech, though Ms. Blake decried a lack of female hires in the department, the context shows she was speaking mainly regarding her personal grievance of her work product being wasted and or feeling a lack of social connection to her male colleagues. I draw the court's attention.
Mr. Piazza, I'll ask you this a similar question that I asked your friends on the other side about the significance of having her supervisor, the person who hired her, Officer Sampson, as one of the individuals whom she aired this to. What is the significance of that as opposed to simply airing a grievance to her peers on the force?
Your Honor, this is very significant for 2 reasons. First, it goes to show that the form of the speech itself was a matter of more of a private grievance rather than one of public concern. But it also shows the expected disruption to the department is greater than if she had chosen a form in which she was perhaps speaking with her supervisor on a one-on-one level. I'll take each in turn. The first shows that Ms. Blake, as a veteran of the police department for 5 years prior to this point, knew or presumably knew of ways to bring matters of concern to her superiors' attention in a professional way, in a way that was likely to minimize disruption. But here, because she was responding immediately to the admittedly juvenile behavior of her colleagues, Officers Wilder and Officer Buchanan, there was no time for thoughtful deliberation, for deciding which was the best avenue to go forward to bring up matters of concern. It was in immediate response to that. As to my second point, that it actually caused potentially more disruption to the department because of the manner in which she spoke to her supervisor, she directly addressed her supervisor and said to him, what are you going to, I quote, what are you going to do about this? There was a pause and then she left the meeting. This had the effect of undercutting Officer Sampson's authority in front of his inferior officers, primarily because she wasn't asking for something specific from him. It was unclear what the ask was.
Mr. Piazza, I want to ask you a question about that. I'm looking at the Judge Pinkney's decision. And my pages aren't numbered, but it's where he notes the email that Blake's behavior at the Winter Parking Committee meeting violated the Washburn police policies. 1, employees shall not demonstrate insensitivity and a lack of respect for fellow officers. And 2, employees shall not engage in behavior that impedes the functioning of the office. When I look at those 2 and I look at the behavior that occurred on that, on the February 6th meeting, you had the two other officers do their presentation, ignore her presentation, walk away from her. They spend time ignoring her on ongoing duties going forward. It seems to me that when I'm looking at insensitivity and lack of respect, it's the other officers who were guilty of that conduct and not Officer Blake. So I sit here and then I look at the firing, and it almost raises the question of why is the victim the one being fired for responding to the bad behavior of fellow officers? That's the concern that I've got with this case.
Your Honor, if I understand your question correctly, and please correct me if I don't, I believe that the key distinction here is that Officers Wilder and Buchanan, prior to this February 6th meeting, have not been alleged to have engaged in any directly discriminatory or sexist behavior. They acted in a juvenile manner by high-fiving about ending work early, but this was not directly targeted at Ms. Blake. On the other hand, as to the—
But Ms. Blake, if I can stop you there, Ms. Blake was next to present at the meeting. They did not want to stay to listen to her presentation.
Your Honor, I'd like to push back on that characterization of the record, because it was Officer Sampson, the superior officer, who decided to end the meeting early, which, as a matter of general knowledge, this can happen regularly.
Which means it's all three.
I'm sorry, Your Honor, would you mind repeating?
All three officers. That's my concern. She is complaining about the fact that she's being ignored, and yet she is the one who gets fired for complaining. There seems to be a twisted logic here that I'm not catching.
Your Honor, again, if I understand your question correctly, I think the key distinction here is that it was Ms. Blake's behavior at the meeting which caused substantial disruption to the unit, to the efficiency of the office in ways that were very potentially dangerous. I'd like to move on to my second point.
I think I may take you to your next point, and it's a follow-up on Justice Butler's question. When there's a claim of sex or race discrimination, and there's disruption in the office because, to put it in perhaps a term you wouldn't like, she wasn't a member of the old boys club, can you really rely on that second piece of Pickering and Connick to uphold determination? When the speech is directed at discriminatory practices and there's disruption as a result of that charge of discrimination.
Your Honor, two quick points to make about your question. The first is, it's worth noting that contrary to my friend's suggestion, my friend on the other side's suggestion, many courts have found that allegations of discrimination were not per se matters of public concern meeting this test we're discussing. The Second Circuit in Ezequiel versus New York City Health and Hospitals Corporation, Kokinis versus Ivkovich, this was a Seventh Circuit case, and even Connick versus Myers itself. So the analysis
But what about Gibbon? Justice Rehnquist's opinion, in which he accepted the notion that a claim of racial discrimination was a matter of public concern.
Your Honor, we're not saying that it's, Your Honor, it's still taken on a case-by-case basis under the Pickering-Connick test in these kinds of contexts. And I'd like to address your second part of your question, which was whether the disruption, whether the nature of the speech was outweighed or outweighs the nature of the disruption to the workings of the department.
Yeah, and just to clarify, it seems to me, at least arguably, that when it's a claim of race or sex discrimination, looking at disruption in the ranks is a much more, it's fraught with a lot more peril, because there's a lot more potential that you're simply giving voice to the discrimination by saying there was unhappiness among the officers with her statement, and therefore that caused disruption and that justified her firing.
Your Honor, it's fraught on both sides, especially a public agency like a police department where officers are engaged in high stress, high tense situations, matters potentially of life or death in a given situation. It is key, as the Seventh Circuit noted in Kokinis, that these quasi-military organizations members be able to rely on each other in tense situations. I draw your attention especially to the incident on February 14th, 2019, when Ms. Blake responded to Officer Wilder's call for backup involving an alleged gunman. there was a potentially incredibly dangerous lack of communication during the interaction. It's incredibly fortunate that everybody involved escaped unharmed, but a police department has a very justifiable expectation or need for officers to be able to properly communicate in these situations. And if interpersonal tensions as a result of certain kind of speech not handled in an appropriate way are going to cause these tensions, then the police department has a duty to its officers and the public at large to not put their officers in more dangerous situations than is already required by their job.
Well,
And I'd
let
like
me ask you this, though. The problem I too have is that, but the one showing disrespect at that incident you're referring to seems to have been Wilder, not Blake. I mean, he's the one who doesn't want to, tells her, oh, ask another female to fill out the report. So why are we blaming Blake?
Your Honor, because the speech in question that is challenged in this case was the speech at the February 6th meeting, which led to these tensions. It is ultimately Ms. Blake who is bringing this constitutional challenge. So we look at the speech which the department relied on and which the department saw as the source of this tension. And I'd like to contrast this case, for example, with Cottarello versus Village of Sleepy Hollow Police Department. This was a Second Circuit case in which the officer there was complaining to a superior officer about discrimination against Spanish-speaking officers. And the court held there the speech was protected in part because he was addressing private letters to a superior, which minimized the possibility of disruption to the further department. That officer was fired wrongfully in that case. But here in this case, Ms. Blake, once again, the context and the scope of her initial speech shows that she was not taking these, taking her complaints or taking her issues in an appropriate manner to her superior officers in a way which would minimize that potential disruption. And that shows two issues. Again, one, that the nature of her comments were of a matter of personal grievance because they followed immediately after her colleagues' high-fiving about their after-work activities. And it also shows a reasonable prediction of disruption to the department. I'd like to also note within the record that there were other instances of disruption within the department. As I believe this was Justice Butler's point, that Ms. Blake herself began neglecting her own work for the traffic committee. This is an entirely predictable outcome. If one is standing up in a committee meeting and directly insinuating that your male colleagues are unqualified for their positions, then there's going to be interpersonal tension, which could, Justice Kistler, I'm not sure if you're asking a question or.
I was just trying to make sure I understood. But I guess my question was: are you arguing that there was an alternative reason that would uphold the firing of Blake under Mount Healthy versus Doyle, or are you arguing that that tension simply shows that her comments caused disruption within the department?
Your second point.
Those at least seem to me two different legal issues.
We are arguing on behalf of your second point, Your Honor. Both sides concede that the speech was a substantial reason for her firing, but by pointing out her neglect to her own duties, we are showing that that was a reasonably predictable outcome of this kind of outburst within a committee meeting where she was engaging with fellow officers instead of bringing her concerns in a more deliberative fashion in a way to minimize those concerns.
Mr. Piazza, much of your first part of your argument is grounded in the fact that this was her issues were raised at a committee meeting. Are you advocating for a bright light rule that is predicated on the setting of the protected speech? Or in other words, a committee meeting can never be a proper setting to raise such protected speech?
No, Your Honor, we are not advocating for a bright line rule. We are satisfied with the legal tests at hand to decide this case. However, we are saying that the setting is a factor, and to describe it in a certain way, if one is going to stand up in the middle of the department and speak to the department as a whole, or perhaps on a news broadcast, then those comments need to be measured and given in a different way than, for example, in a private letter to one's superior, because the comments given, say, to a television broadcast or spoken in public to the whole department have a far higher likelihood of disruption to the department if they are not given in a measured or deliberate way. And because the Pickering-Conant balancing test does measure the substantial nature of the speech itself against the potential for disruption, then the speech is naturally going to be more protected if there's less possibility of disruption and if the significance of the speech is higher.
I'm going to give you a chance to I know your time is almost up, but I was a little bit put off by your third point that you made initially, so I want to give you a chance to convince me that it's not exactly what you said it was, or maybe it was, that the specific nature was not sufficiently important. And so this issue of not hiring enough women or discriminating against women at hiring, which was part of what the speech was here, why is that not important? You can answer.
Thank you very much. To clarify, it is not necessarily that the subject of lack of gender diversity is not important enough. It is that it seems to be from the record that Ms. Blake's specific ask, if you will, is not necessarily enough of a matter of public concern, because the nature of her comments seem to be the case that hiring more women in the department would allow her to be more comfortable on an interpersonal level. I again draw that the last sentence of her statement is, if there were only another woman here to understand my struggle, and seemed to suggest that she believed hiring more women would somehow result in officers Wilder and Buchanan acting less unprofessionally. So it's one step of a tenuous connection that if the ask were a little bit more clear about specific policies of the department or who was doing the hiring, then perhaps that would weigh differently in the Pickering-Conant balancing test. And for the foregoing reasons, we respectfully ask that this court affirm the 14th Circuit Court of Appeals below. Thank you very much.
Thank you.
Two points on rebuttal, Your Honors. First, regarding the Twitter issue. In regard to Justice Joseph's question on the rule, Respondent proposes a rule that would burden the courts and further muddle the waters by asking them to make two different standards for when an executive official is a state actor and when a legislator is a state actor on social media. Only two questions need to be answered. Does the account look governmental? And does the account act governmental? Here, the answer to both is yes. Representatives are government actors with substantial power and influence. Here, Respondent is responsible for protecting the right to free speech, not infringing upon it, and in turn eroding the foundation of the democratic process. And second, regarding Officer Blake's First Amendment rights. To address Justice Butler's concerns about the twisted logic going on here, you are exactly correct, and I will simplify it. Officer Sampson cut out Officer Blake's presentation so he could go to the bar and drink beer with the other male officers, which was in direct violation of Washburn Police Department Policy Number 1, officers shall not demonstrate insensitivity and a lack of respect for fellow officers. Officer Blake responded to such lack of respect and insensitivity. Officer Sampson was not fired for violating Washburn police policies, and Officer Blake was. Officer Blake was fired for her speech, and the Washburn Police Department hid behind its policies. Your Honors, Officer Blake was courageous as she decided to stand up and speak out about the injustices taking place within the Washburn Police Department. She should not be punished in the name of, as opposing counsel put it, justifiable expectation of disruption, especially where no real disruption resulted from the speech. Thank you.
Thank you.